So this is her, so she been for proof.
Yeah, these are her stuff she paid for.
You gonna prosecute?
Yes, sir. Of course.
Welcome back to Advocacy Alchemy with Professor Ross. Today we have a good one, guys. This case is a perfect example of how the law applies to everyone. And yes, I mean everyone, even those who wear the badge. We're breaking down the story of a Georgia police officer caught shoplifting at, guess where? Walmart. She was charged, but not with theft, but disorderly conduct. Then she lost her job. Why was she given a different charge? Was it a fair outcome? And what does Georgia law say about shoplifting versus disorderly conduct? Let's jump in, guys.
That's all that's hers, right?
What up?
My bad, Jess.
So this is her, so she been for proof.
Yeah, these are her stuff she paid for.
You gonna prosecute?
Yes, sir. Of course.
I was around the corner, that's okay. Sir. I ain't riding yet.
2733, copy all line. No.
Any reason?
Yes, sir.
Any reason? Reason why you didn't?
Oh, I just got arrested. I have no motion.
You have a money?
No, I'm good.
2733. Go ahead.
0.
Now let's do a regular Brittaine Pooler at a jump for no one.
Clear, thank you.
Have you been caught at Walmart for this ever?
This is my first time ever.
First time?
I've never been into it
Ever? Ever?
ever.
No tickets? No?
Ever.
Yeah.
That's cool.
No, not true.
2733, case number.
You're missing a couple of rings right now. Now I gotta go back to
5910, 5910.
You don't want to check it really. And you'll get no Walmart ring. Why not? It's not my style. All the ones that are good. No! Why? Are you married to Susie Clan?
You're married to Walmart, might as well.
I want a divorce. Say that was a lie. Jessica might be a judge on that one. I'm married to Walmart. I'd like to report domestic violence.
Yeah.
911 at Cambridge Parkway, 911 at Cambridge Parkway. Street of Flagstaff Drive and Cottonwood Lane. Now, two black males, one with a blue hoodie, the other is shirtless. They're looking at people's sheds and trying to open doors to the sheds. You get $30 to complain at 911 Cambridge.
Yup.
First time.
Show me on a short one.
So they're on a trespass, so
I'm
you can come shop again on Walmart.
1810,
You can go to any Walmart. Or say, Sam's Club.
11763, 11763.
You can't even touch the trails that being pulled by Swift. But then this officer is going to issue a citation to appear in court. So you kind of arrested, but you're not arrested. So you have to appear in court. You don't appear in court and take 1 for your arrest. And then you're definitely going to have a lengthy record.
How old are you? 20.
Go ahead. This is order representative 82. Get back around to 16.
What's your current address? Riverview.
So can I get my record clean?
Your record clean? Right now, you got nothing in your record until you go to court. They find you guilty at court. It's gonna show that you were,
Theft by shoplifting.
it's gonna show that by shoplifting conviction. That doesn't mean necessarily that you went to jail. You gotta going to jail. It's just kind of like you go in there, you see the judges and not whatever. It's happening so often that if we take everybody that shoplifted to jail, we have to.
It'd be overcrowded.
So I can get my record like clean.
You cannot get your records expunged though. But usually, when you tell the judge, hey, what you told me, and you being video recorded, you tell me, hey, I just got to the hospital and had the funds. Yeah, that's what you say, right?
Yeah.
You.
I literally just got out yesterday.
Okay, but you stole the merchandise.
Right.
Okay. So you tell her, yeah, I did, Judge. Well, she will find out, you know what, well, I'm going to put you in probation, this and that, so you can learn your lesson, or, okay, I'm going to charge you with type of shoplifting, and it's going to be your record.
Huh?
It takes a while.
Yeah,
to get your
2100
record.
5910.
What are you trying to do, if you don't mind me? Because you're asking because you're trying to do something.
Yeah, I'm in school. My graduate December.
For?
From the district.
You cop? Huh?
No.
Definitely not. What am I being a cop?
Bad reputation.
Huh?
Bad reputation for me.
We have you don't know me.
Yeah. I didn't say you. I said y'all.
Every officer.
But it's just police in general. Like when you say police, you just automatically think of everything that's going on.
So every student goes to college, he goes to school, is a pothead and a drug addict.
Probably, I don't know. But I'm just saying. But that's just when you look at the police, when you think of it, just in general. Not saying you're one, but
I got you.
I haven't met a bad cop, honestly. But just the news and media and stuff, you know.
Exactly. That's why I don't look at the media, because it's all. Look, I have my fair share of bad encounters with the media, where I've been to many accidents, in the sense I work many accidents. Where always you see them in the news, I go, what? That's not what happened.
Yeah.
The most recent, we had a motor accident, and they said this guy came this and that, whatever, from this, and the motor accident. No, that's not what happened. The lady was doing something wrong prior to driving, got in the vehicle, behind the wheel of the vehicle, and crashed into the motorbike. That's what happened. But
Yeah, it's just social media. I mean,
so what are you going to come and listen for? Huh?
Probation.
Probation?
Juvenile.
God bless you.
Yeah.
God bless you. Patience.
Yeah, so I can get my record clean.
Clean your record or give you something less. I'm just saying, she might say, you know what? You got me less than I'll put in probation for 180 days. Cleaning the city of Riverdale, and I don't know. And after that, she'll,
Sign on that line.
I don't know. I cannot say what she's gonna do.
What have you seen the most of?
Well, I don't do that. You know what? I'll give you that as some, because of this stuff right here. I don't deal with people like that. I'm a traffic officer.
So what you deal with the other police?
Everything and anything.
I mean, I do everything, but my main cup of tea is traffic. It's a one-way conversation.
This guy, he's a hero.
No, I'm not. Oh, this guy? Yeah.
Who, me? Why?
Yeah. You never see Toy Story?
Oh, you.
Oh.
Geek. Let it out. This is your copy. Your court date is going to be. Yes, you did. Your court date is going to be the August,
Thank you.
3rd of August at 11 a.m. at this address. Okay.
One day.
Okay.
And here's your license.
Okay, come.
I got it already. 5910. And
All right, the time is 16:07 hours on Wednesday, March 16th, 2022. Present in the admin conference room of the College Park Police Department is Jailer Brittaine Pooler, Captain Nicholas Duffy and Captain Boyd Burns. Ms. Pooler, I'm going to read a couple documents to you. The first document is the College Park Police Department warning and assurance to employee required to provide information. This is an official administrative investigation regarding misconduct or improper performance of official duties. In accordance with the Privacy Act of 1974, you are advised that the authority to conduct this interview is contained in Chapter 5, Section 3B, Rule Number 22, Internal Investigations of the College Park Police Department, Rules of Conduct and Standard Operating Procedures. This inquiry pertains to an arrest. The purpose of this interview is to obtain information which will assist in the determination of whether administrative action is warranted. You're going to be asked a number of specific questions regarding the performance of your official duties. Your cooperation in this investigation will include any lawful request or action deemed necessary by the authority of the Chief of Police, including submittal to a polygraph examination. You have a duty to reply to these questions, and agency disciplinary action, including dismissal, may be undertaken if you refuse to answer or fail to reply fully and truthfully. Neither your answers nor any information or evidence gained by reason of your answers can be used against you in any criminal proceeding, except that if you knowingly and willfully provide false statements or information in your answers, you may be criminally prosecuted for that action. The answers you furnish and any information or evidence resulting therefrom may be used in the course of agency disciplinary proceedings, which could result in disciplinary action, including dismissal. There's an acknowledgement that says, I have read and understand my rights and obligations as set forth above. So, Ms. Pooler, this was something that you brought to our attention, and we appreciate your candor in bringing it to our attention. Anytime an employee has a run-in with law enforcement in an official capacity, outside of the scope of their job duties, we have to do an investigation. So it is my understanding that there was an encounter with Riverdale Police Department on June the 11th of 2021. Do you recall that event?
Yes, sir.
All right. To the best of your recollection and in your words, walk me through what transpired that day.
I had just gotten out of the hospital. I went to Walmart to get some groceries because I had to come to work. As I was on my way out, someone came up to me and told me to come into a room. I went into the room. They asked, did I know why I was there? And I told them no. And they said I wasn't scanning my groceries. And I told them that I wasn't aware of, and I was explaining to them my situation and everything. And then they told me, well, they ended up calling the police, and then the police came and then they wrote me a citation, and I was let go.
Okay. What was the citation for?
The citation was for shoplifting.
Okay. So, with every citation, there is a court date or an option to handle out of court in some cases. Did you attend court on this?
Yes, sir.
All right. And what was tell me about court.
I went to court. Instead of charging me with shoplifting, they charged me with disorderly conduct. They asked me to pay a fine that I didn't want to pay then at that time. So I was put on probation to pay the fine. I paid the fine within the same month. I believe it was the same month.
They reduced the charge to?
From shoplifting to disorderly conduct. Correct.
All right. Was this any kind of plea deal? How did this transpire that all of a sudden they charged you with disorderly conduct?
I had a public defender. She talked. I didn't talk at all. She just came over to me and told me everything that I needed to know.
So through the public defender, charge was reduced to disorderly conduct. They issued fine. You couldn't cover the fine. They put you on probation until such time as the fine was covered. Okay. Has this been reported to Post?
Yes, sir.
Okay. Have you received any kind of notification from Post?
Yes, sir.
Okay. Is there anything about this that we need to know or understand? You made mention that you explained to them your situation. What was the situation that you explained?
That I had just gotten out the hospital.
Okay.
And that and I also told them that, I wasn't aware that I didn't scan out my groceries. If I need to go back and pay for something, I didn't. I could.
Okay. Did they give you the opportunity to pay for anything or go back and scan your groceries?
No.
Okay. Do you recall how much money was stolen as far as groceries?
Maybe 50 something. I'm not sure.
Okay.
The exact amount.
$53.01 sound familiar?
Yes, sir.
Okay. What portion of the items did they say you didn't scan? Was it a large number of items or one major item? Or did they tell you?
I can't remember.
Okay. What made you bring this to our attention?
I was talking to, well, me and Sergeant Walker was talking about a case that Officer Davis had, and I just pulled her to the side and asked her about it. Asked her, should I mention it?
Okay. And what instructions she provided?
She told me to bring it to you.
Okay. Captain Burns, you have any questions, sir?
I think I saw you reading the police report. Were you actually taken into custody or just written a citation?
Written a
Released on it?
citation.
Was there any actions that warranted disorderly conduct on your behalf, or was that just something the public defender worked out in court?
I guess it's something she worked out.
From,
'Cause
go ahead.
No, go ahead.
I do have one of their body camera videos, and it appeared she was very civil with them.
It just seemed kind of odd that you go.
Yeah, it appears that it was just a release on copy, and based on what I can see here, it looks like it was just a plea deal to reduce it to something minor. So what was the sentence that they imposed? Do you remember the fine amount and such?
Before, well, I know I had to pay a certain amount of fees, but I think in all I ended up paying maybe like $800 or $900. It may have been $9.
Okay. Judging by the document here, it looks like the total fine was $600, it appears, and then you had a $250 fee, and then $30 a month, something like that as far as a probation fee.
Yeah, I didn't make it to the $30 because I paid it all in the same month. That was just if you couldn't pay it, if it kept going on certain months.
Okay.
But I think the fees I'm talking about is more so like paying over the phone, like credit card fees or something like that.
Okay. All right. So it looks like I've got two receipts here, one for $468 and one for $466.96. I'm assuming both of these would have completed your debt to the court. Is that correct?
Yes, sir.
Okay. Do you have any questions for me, Ms. Pooler? Okay.
Oh, wait, yeah. So am I still supposed to meet with Chief?
So what happens here with the IA is I finish up the IA and I submit it to the majors. The majors look at it and then they submit it to the chief, and the chief makes any kind of determination.
Okay.
Obviously, seeing that there was a finding of guilt on this, looking at the court document, it's marked that you were found guilty and you were sentenced. So that constitutes a violation of law based on the actions of the court. Obviously, that's a violation of our SOP, so there will be SOP violations that the chief will need to consider. What she does with that, how she does it, when she does it, is all within the purview of the chief.
Right.
All I do is I gather the facts, weigh it against the SOP, and say, Chief, this is where we stand.
Right.
I know she is in class this week, not that she is not reachable, but I would not expect any kind of action or meeting scheduled for a week that she's scheduled to be in class.
Right, gotcha.
Any other questions?
No, sir.
All right. Captain?
No.
All right. Well, if there's nothing else, it is 16:19 hours, and I'm concluding this interview.
I think it's important to remember that we saw not only the security footage from when she was brought into the office to be questioned about the potential theft, but also we had the administrative hearing that happened some months later, there on March 16th of 2022. And that gave us the opportunity to hear her side of the story. Now, at this point, she wasn't booked into jail, but she faced still some legal consequences. Let's look at the law and let's see why. First, we'll start off with shoplifting, or as it's termed in the Georgia statutes, theft by shoplifting. This is found at section 16-8-14. Georgia law defines shoplifting as taking merchandise without paying, altering price tags, or manipulating the checkout process. This includes skip scanning at self-checkout. If the value is under $500, it's a misdemeanor. It carries still up to 1 year in jail and a fine of up to $1,000. Keep in mind that repeat offenses escalate the penalties. By the time you have the fourth offense, it becomes a felony automatically. Let's move into the second charge or potential charge. The one she did have, disorderly conduct. Now this is found at section 16-11-39. Remember, instead of shoplifting, she was charged with disorderly conduct. Why? Let's talk about some of the possible reasons. Maybe it's because she's a police officer. Simple one. Next, prosecutors might have wanted a quick resolution that would end with just a fine. She might have negotiated a plea deal to avoid shoplifting convictions coming onto her record. Let's talk about police ethics and consequences. Even though the criminal charge was minor here, disorderly conduct that's the charge you get most of the time when people are fighting at a bar or something like that, or somebody's cussing in the store with kids around. We have charges with distinct names for specific reasons. If a person is stealing, you charge them with theft. If a person is acting disorderly, you charge them with disorderly conduct. But that aside, police officers are held to a higher standard. Any criminal offense can result in termination. The administrative hearing video, it starts about halfway through, at about 9 minutes in. It shows that the department had no choice under their policy. So though they may have wanted to make an exception, being untrustworthy is not going to be the way to go if you're going to be police. All right, next let's move into the evidentiary standards. Remember, these standards are important, and this is how a case is processed from the investigative phase with the police all the way through conviction at trial. We start off always with the lowest rung. That's mere suspicion. That's a hunch or a vague feeling that something might be wrong, but there's no concrete facts or evidence. A good example is the Walmart security noticed unusual activity at the self-checkout. They didn't have proof of wrongdoing just yet. Number 2, reasonable suspicion. This is a specific and articulable belief that a crime has been, or is about to be committed. An example, the security saw the officer, the woman who was caught stealing, failing to scan certain items. Remember, she was at the bottom right-hand corner of the screen, skipping items and putting them right in her bag and trying to be slick with it, but not being slick at all. All that justified further investigation. Number 3, probable cause. This is a reasonable basis for believing that a crime has occurred, and this allows for an arrest or a citation to be issued. A good example is the Walmart security footage confirmed unscanned items, leading to the responding officer to issue a citation. Remember, this is in the city of Rivendell, Georgia. All right, number 4, preponderance of the evidence. All right, it means more likely than not. All right, this is used in civil cases mostly, and sometimes you'll find it in administrative hearings, but the next one is more so. All right, but more likely than not, 51% of the evidence must point to one person's side or one person's claim being true in order to win. An example, Walmart's records and video provided enough proof to justify some internal disciplinary action against the officer. Number 5, clear and convincing evidence. This is a high level of certainty. We say about 75% of the evidence needs to be there and pointing to your claim being true. This is also used in civil cases and more so often employment administrative hearings. It's also used in family law cases too from time to time. A good example is the body cam footage, store receipts, and testimony strongly supported the department's case in the disciplinary hearing. So they would need more than just a 51% amount of evidence pointing to the claim being true. All right, you would need a little bit more, need some testimony, like they're saying. You're gonna need something to show that the person actually did the wrong that you're talking about, because you're going to fire them after this, right? That's what happens that's what happened at this disciplinary hearing for her. Lost her job. Number 6, beyond a reasonable doubt. All right, this is the highest standard of proof in the American jurisprudence system. All right, the American justice system uses this for criminal law cases, requiring no logical reason to question the guilt in the criminal case. This requires that the evidence be so strong that there is no doubt. There is no reasonable doubt. All right, so we're not talking about imaginary doubts, but there's no good doubt. We say this takes anywhere from 90 to 95% of the evidence needs to point to a person having committed the crime and not pointing to anything else. A good example is rather than fight a possible shoplifting conviction, the officer pleaded guilty to disorderly conduct in court. All right. So pleas also instantly allow beyond a reasonable doubt. A person is accepting the charge. They're saying, I did do whatever the charge is. That's why it's a plea. You're pleading for mercy based on acknowledging that you did do the crime. All right, let's move into our next one. First, let's talk about the right to a jury trial in Georgia. In Georgia, any defendant facing potential incarceration, doesn't matter if it's for a misdemeanor or a felony, there's a constitutional right to a jury trial. For misdemeanor cases, and that means basically you be punished up to 1 year in jail. All right, they usually have 6 persons on the jury. All right, felony cases, and that means any time that you could face punishment over 1 year in prison. In the two terms, jail and prison, they use them, and people think of them as the same, but usually jail means you're being held at the county level, and you go to prison at the state level. All right, prison is for felonies, and the state you'll become a ward of the state for however much time a person is supposed to be in the system for that punishment, anything more than 1 year. All right, felonies require a 12-person jury. Okay, United States Supreme Court has ruled that offenses punishable by more than 6 months in jail require a jury trial. Even when a case starts in potentially a judge-only court, we say something like a municipal court, a city court. A defendant can demand a jury trial by appealing or transferring the case up to state court or a superior court, wherever the court is in your location. So if you're in the United States, you're charged with a misdemeanor and you want to fight it, you can appeal up to the next level, the felony court level, and you can request a jury trial and receive one. Okay? All right, and there was a 2003 case in Georgia, Ging versus State. This is Geng versus State. In that case, the Georgia Supreme Court did affirm, or they reaffirmed the case law that says that misdemeanor defendants facing jail time cannot be denied a jury trial. If you potentially are facing your liberty being taken away, and you've been placed incarcerated or incarceration, either in jail or prison, you always have the right to go to a jury trial. Next point, let's talk about some of the considerations for a jury in this case. Now, if you were on a jury in this case, let's think about some of those. If the officer had not accepted the disorderly conduct plea, she could have demanded a jury trial on the original shoplifting charge. Now, based on the evidence that we saw here, all right, you saw the video there in the bottom right-hand corner that was showing her skip scanning. Do you think that was enough for a conviction of shoplifting? Do you think she accepted this deal because she feared a worse outcome if she went to a jury trial? That's another thing to think about. And that's not necessarily as a juror, but just as a student. That's the reason why people take a plea deal versus going to trial. Do you think that if you were on a jury with her status as a police officer at the time when she committed the crime, do you think she should face harsher jury scrutiny? Do you think you should expect more of a police officer than a regular citizen when charged with the same crimes? I encourage each of you, please leave your comments below on what you think about this situation. If you were on a jury, how would you rule? This case is a reminder, small crimes can have big consequences. Whether intentional or accidental, skipping $53 worth of items cost this officer her career. What are your thoughts? Should she have been charged with shoplifting? Was firing her too harsh? Do you think it was justified? Let's discuss all this in the comments. Remember, this is Advocacy Alchemy. I am Professor Ross, and I'll see you tomorrow. Everyone have a good day.